Hello, everyone, and welcome to this SCC Online Seminar on Dispute Resolution Online. My name is Kristin Campbell-Wilson, and I am the Deputy Secretary General here at the Arbitration Institute of the Stockholm Chamber of Commerce, the SCC. We are currently finding ourselves in the 9 months into the pandemic here in Europe. The ongoing pandemic has changed all of our lives across the globe, and we have now had many months of getting accustomed to working from home, becoming acquainted with several different video conferencing platforms, and also showing all sorts of different aspects of our lives in front of the screen. These are challenging times for everyone, but there is every cloud has a silver lining, and in terms of international arbitration, digitalisation is one of them. Our industry is currently seeing a very fast and quick adaptation to digitalisation and doing things online at a speed that we've never seen before. We have seen, since the pandemic, we've seen ongoing arbitration cases having to adapt to the new scenario. We've also seen completely new arbitrations which have been dealt with consistently and throughout the entire proceedings only online. This is very exciting, a very exciting development we find here at the SCC. And today's seminar will highlight and introduce to you specifically the SCC Platform and its sister, the Ad Hoc Platform, which is, both are case management, digital case management tools that are used. The SCC Platform is the tool used in SCC arbitrations to send and communicate in a cyber-secure way in SCC arbitrations in between the institution, the arbitrators, and the council. So before we start today, I need to give you some housekeeping rules. We have put all of you on mute, which means that I cannot see you and hear you. We've also turned off the video for everybody, so I can't see you or hear you. But I have my colleague Lise Alm here to help me keep track of any questions that you may have, and that you are encouraged to put down in the chat function. You should also acknowledge that we are currently recording the seminar and that the seminar may be published on the SCC website. I have prepared the following agenda today. As many of you and the people who have signed up for this seminar come from various different corners of the world, I thought it appropriate to start off by telling you a little bit about the SCC and the role we play in international arbitration, as you may not necessarily be accustomed to the SCC and SCC arbitrations. I will then move on to introduce to you the SCC Platform and the Ad Hoc Platform, and briefly touch upon a recent survey that the SCC did, which dealt with information on virtual hearings that I'd like to share before we finish today. There will be time at the end for a Q&A session, but please encourage you to use the chat function and not wait with your questions if you indeed have any ones that you would like the answers to. So I think that was all about the housekeeping rules. The SCC is short, as I said, for the Arbitration Institute of the Stockholm Chamber of Commerce. The Arbitration Institute is a department of the Chamber, and it was established in 1917. Since then, we have grown into one of the major international institutions offering dispute resolution services in international settings. And this is thanks to various different events, but three major events that helped put the SCC on the global arena happen in the 70s and 80s. The first of which is the optional clause agreement that was agreed by the US and the USSR in 1977, whereby these two blocs decided that any business disputes would be resolved in neutral Sweden at the time. So that was the first stepping stone to the international spotlight, let's say. In 1984, China followed suit by entering into a cooperation agreement with the Stockholm Chamber of Commerce, whereby the SCC was acknowledged as the then only international institution to deal with China international disputes. And in 1993, we registered our very first investor-state dispute. Today, only a few decades later, we see about 150 and 200 cases per year being registered at the SCC. These cases involve parties from approximately 40 different countries every year. What we can see, though, among these cases is that we still have a strong sort of east-west characteristic to our disputes. A lot of them involve energy disputes. And as I mentioned, investment arbitration is also a characteristic of SCC arbitration. Since 1993, we have registered more than 110 investor-state disputes at the SCC. Most of these have been administered under the SCC rules, which indeed makes the SCC second to ICSID in the world dealing with investor-state disputes. At the SCC, we have a number of different sets of rules. The two main bodies of rules are the arbitration rules and also the rules for expedited arbitration. In 2010, we included provisions on the appointment of an emergency arbitrator. This is a new feature in international arbitration that has really become a very common feature. Also both well-known and often used feature in international arbitration. We also perform services in ad hoc proceedings, including uncitral arbitrations, where we act as appointing authority. Since 2015, we can also administer uncitral arbitrations upon the agreement of the parties. And we have indeed mediation rules as well. So to sum up the key features of the SCC and SCC arbitration, as I mentioned, it is today an internationally recognized institution where we see as many as 40 nationalities represented in our statistics every year. The SCC is an impartial and independent body. It is a member organization, and this is perhaps in contrast to other institutions who are either funded or part of a governmental body. We have over the years been acknowledged or recognized as an innovative institution. And we have a very strong focus on time and cost efficiency, which is also part of the reason why we have been at the forefront of innovating the industry. Here I've included a picture or a map which depicts from where our parties come from. As you can see, most of our cases involve Swedish parties, and that is because approximately 50% of our caseload each year consists of domestic disputes, and the other half is international. And when you look at the international parties that we see here at the SCC, Russia usually comes out on top. Also last year, followed by Germany, the US, and the United Kingdom. But you see also our neighboring countries very high up in the statistics, like Finland, Denmark, and Norway. So what do I mean about when I say talk about innovation and arbitration here at the SCC? Well, we do so in many different ways, but we do it both in as regards procedure and by use of technology. One example is the rules for expedited arbitration that we've had here since 1998. This is a topical question currently and being dealt with or is subject to the working group 2 of UNCITRAL. And it also is being discussed in the investor state context at ICSID. So we have at least more than 2 decades worth of experience when it comes to expedited arbitration. And as I mentioned, the introduction of the emergency arbitrator provisions in 2010 has shown or has proven to be a real innovation in arbitration and can be found in most international institutional rules today. When it comes to digitalisation, that has been a strong focus of the SCC in the past 8 years. Our first digital initiative took place in 2012 with the introduction of the Swedish arbitration portal. And this was an initiative to make more readily available Swedish case law to our international users. So the arbitration portal includes a number of Swedish court judgments related to arbitration translated into English. In 2013, we left the paper trail completely and operated in a digital case management setting, including receiving requests for arbitration via email and then otherwise in electronic form. But the major event, I would say, that has had a tremendous impact on our users is the launch of the SCC platform in September 2019. So before I move on to introduce more about the SCC platform, I will ask Lise, my colleague, if there are any questions so far.
No, there aren't any questions to date. We have an interesting little chat going on about the origin of the SCC, but there are no questions today, at this point.
All right, thank you very much. So let's continue. The SCC platform was, as I mentioned earlier, it is a communications and file sharing platform that provides this sort of communication in a cybersecure way between the institution, the council, and the arbitrators. And this was a feature that had been demanded for years in the industry that something of this sort would be desirable in order to make more efficient the procedure. And it had also been on the list of well, on the SCC's to-do list for some years, but in August of 2018 it reached the top of the list of priorities, and Lise and myself sat down to discuss what we wanted to achieve and what features such a platform needed to have in order to be successful. And this is the wish list that we came up with. We knew, of course, that this platform would need to be relevant, and it needed to be relevant for arbitration and the peculiarities of arbitration. There has been for many years similar platforms used by our colleagues in mergers and acquisitions and in other areas of law. But when it comes to international arbitration and the proceedings, it needed certain features that our future platform needed to accommodate for. It also needed to be user-friendly. As a member of this community and the legal community and previous lawyer, private practitioner, I must say that we are not known to be at the forefront of technology and to take on board technological advancements to a very high degree. This platform needed to be user-friendly to cater for both those who are tech-savvy lawyers, but also to cater for those who are not. The platform needed to be intuitive and easy to navigate, and that ties very closely to security as well. The platform itself needed to be easy for anyone and be based on sort of a simple interface, and also have embedded safeguards as to minimize human error. It also, of course, needed to have technical security, and the servers of the platform are located in Germany, and there are backup facilities also based in Germany, which was also important to the SCC as the jurisdiction of the storage is of great importance as well, and Germany has a very secure data protective legislation. It also needed to be included into the services of the SCC. We work on a fixed fee basis, a schedule of cost, which is determined by the amount in dispute. And we did not want this new feature of SCC arbitrations to result in discussions between the parties and become another point of dispute as to whether or not to use it. So it is included in our services as a party to an SCC arbitration. We have, further on, when it comes to the use of the platform, the SCC will only communicate through the platform. This means that at least one individual on either side of the dispute, one on the claimant side and one on the respondent side, as well as the tribunal, need to interact with the platform to some extent, and that is to receive our communications. Beyond that, it's actually up to the parties and the tribunal to decide among themselves if they want to use this case management tool in order to manage the arbitration post-referral. And as I mentioned, it is included in the administrative fee of the institution, that is access and the use of the platform is free. It's included. Storage of data is also included in the majority and in the vast majority of our cases. But we also decided, as we do see some very large cases at the SCC and very document heavy cases, we needed to have some sort of vent or ceiling beyond which we will charge a small fee for the extra storage of data that is required in that particular arbitration. But in the vast majority, this is indeed included in the administrative fee of the institution. And here is a sneak peek of what the platform looks like. It involves several different functions. It was important to us not to clutter it with too much information or features that is not relevant in an arbitration, for instance. This was incredibly important at the launch of the platform in order to persuade our users to use it and to feel not intimidated by the platform, let's say. So when you enter a site, which will happen only on the invitation from the institution. So when, upon the request of arbitration, we will invite the claimant's counsel to access a particular site on the platform that is dedicated to this particular arbitration. That counsel will need to, as a first-time user, will need to create his or her profile or fill in the information that is relevant, such as contact details, etc. So any individual that has access to a site on the platform will have a platform profile that will be used for any and all of the arbitrations that he or she may be involved in. The other side, or the respondent side, will be invited to access the site on the platform together with the service of process. The arbitrators, however, will be invited upon referral of the case to them. And as you can see here, you have a general information page, which is the landing page of each site. This is a mock site, of course. It's between Candy AB and Tooth Fairy LLP. But on the landing site, you will have a good overview of where you are in the procedure or in the proceedings. You will see in this particular picture, you can see who at the SCC is administrating this particular arbitration. You can see who sits on the tribunal and who the claimant and respondent representatives are. You also have a case calendar for the parties and the tribunal to use, and where you see what happens next in the procedure. In this particular one, it was a submission deadline in 17th of November 2019. And you will see what recently uploaded files have been uploaded. If you look at the top, I will try and use my arrow, and I hope you can see it. The tab at the top, which will probably be the one most used by the participants in the arbitration, is the Files tab. This is where all the documentation, all the procedural orders, everything that has to do with the arbitration will be uploaded. There is a set folder structure in each case, and the parties have three folder structures to choose from when they start their arbitration, and in what sort of structure they're going to use throughout the proceedings. The calendar function I mentioned, but if you look at what's called tribunal notices, this is a blog post function that is for the tribunal to communicate practical information that can relate to hearing dates or venues and other information of that nature. That is a function that is for the tribunal to use to communicate information to the parties. However, the parties can respond to those posts and those notices by commenting on them. Lisa, let me know if I have any questions so far.
No, we don't have any questions. If there's anybody who do have any questions or want to make any comments, please feel free to use the chat function, and we'll make sure that we'll feed them in.
Thank you. Right. So the SCC platform was launched, as I mentioned, in September 2019. So we have now celebrated its first birthday. And to sum up, it's been a very exciting year. It's been very well received by our users. So far, we have administrated 270 cases on the platform, involving more than 3,000 participants. Of those participants, approximately just over 1,000 are unique users or unique individuals. We have approximately 150 to 200 people logging into the platform on a daily basis. And we've also added functionality throughout the year. I mentioned that each arbitration site is installed with certain folder structures for the parties to choose between, but we've also made it possible to now request a certain folder structure. So a bespoke folder structure possibility we can offer now. We've also made sure that all materials are OCR readable, which was not the case when we first launched the platform. We've also partnered up with a company called Exhibit Manager. Well, the product is Exhibit Manager, which is a digital tool to help create e-bundles and structures, which is a program used by a lot of law firms around Europe anyway, and especially as far as we know here in Sweden. Now the platform is compatible with that program. We know that there are other programs used by other law firms, and we are looking at extending this particular feature of the platform. And we've also made DocuSign accessible within the platform. These are very exciting features, and we are looking to continuously improve the features of the platform. But one of the most important events that happened this year is, of course, the launch of the platform's baby sister, the Ad Hoc Platform. The Ad Hoc Platform was or is the result of the pandemic. As we went home, we picked up our laptops in mid-March and started working from home. We saw that the SCC platform very much came very handy to our users, and we could continue providing our services without delay in SCC arbitrations. However, we realized as the pandemic progressed that our colleagues who were involved in ad hoc arbitrations had no support of of course, any institution, and needed something similar to that of the SCC platform. So we partnered up again with our supplier, HiQ, which is the supplier of this particular platform, or the SCC platform. It's owned by Thomson Reuters, and this is a joint initiative to accommodate and help those who are dealing with ad hoc arbitrations under these very particular circumstances. And to give you a short rest from my voice, I will show you a video explaining more about the ad hoc platform.
This is the Ad Hoc Platform. The Ad Hoc Platform is a secure way to share files and case material in an ad hoc arbitration case. It allows parties and tribunals to share submissions and files, maintain a case calendar, and have a joint overview of the full case. The Ad Hoc Platform is provided by the Arbitration Institute at the Stockholm Chamber of Commerce, but it's a standalone service for any ad hoc case around the world, and the case does not need to have any connection to the SCC to use the platform. During these special times, it's important for us to help out where we can. Therefore, the Ad Hoc Platform is free of charge for any case that is started on the platform during the COVID-19 outbreak. To learn more about the platform, please visit our website.
So the Ad Hoc Platform is a separate instance from the SCC platform, but it's based on the same technology, and it is structured in a similar, easily navigated way, and has a simple interface. This is, as explained, available to all ad hoc arbitrations across the world, and it has nothing to do with the SCC. It doesn't have to be related to Stockholm, Sweden, or us to be able to be used in an ad hoc arbitration. It also does not mean that the SCC would in any shape or form become the administrating body of that particular arbitration. It is a standalone electronic service that we do offer together with Thomson Reuters free of charge during this pandemic. We have, together with Thomson Reuters, in light of the current second wave of the pandemic, as we see all over the world, decided to extend the time frame for the use of the ad hoc platform to May of 2021. And that means that anyone who needs to use the ad hoc platform can do so free of charge if registered by May 2021. And another topic, which is, of course,
Kristin?
Yes?
Before you move on, we have a couple of questions here. So one question is in terms of pricing for the ad hoc platform. I got a question whether or not it is free also for proceedings that started before the pandemic, but are still ongoing. Ad hoc proceedings, that is.
Yes. That is, should you so wish to use the platform for your ongoing arbitration, yes, of course, that is included. It is all to do with when you register on the platform. It is there to cater to exactly those scenarios. So ongoing arbitrations are welcome to use the platform. With that, it may be worth mentioning that the parties and the tribunal would be in charge of uploading all of that documentation that you need and that you have in that arbitration on the ad hoc platform. That is not something that the SCC would do for you, but rather that is in the hands of the parties and the tribunal to upload all the material in the arbitration on the platform.
We also have a question about DocuSign. We got a question about the whether or not we are planning on doing turning on also other signature e-signing tools.
That is probably a little bit premature, because this is has just been readily available on the platform. I would not rule out other features or other signing software or e-signing software, but it's a little bit too early to tell.
And I can add to that one as well that DocuSign and our provider has their own collaboration, which makes integration with DocuSign specifically extra easy for us. And also, since we are usually the one initiating the signing in a arbitration case or in the administration of it, then it actually goes quite far to cover our needs for now. We also have another question, practical question. Is it possible to have additional people like external counsels be giving access to a case during a weekend, for instance, in an EA proceeding?
Could the person asking that question perhaps elaborate on that question? When it comes to the SCC platform, we will only invite individuals who can present a power of attorney. So when it comes to party counsel, external counsel, yes. I mean, upon the presentation of a power of attorney, we can extend it. I mean, send invitations to external counsel. I suppose that this question was in relation to in-house versus external counsel.
I believe so. Yes. So I mean, the standard is that the external counsels are actually probably the most active ones on the platform. So they will have access, as you say, as long as they have proxy.
Yeah.
I also got a question, and I can just answer it straight away. Is there a presentation video demo on the ad hoc? And there is actually. So the one that you saw now was a brief version video, but there is also a slightly longer version with a more extensive demo on the web page.
Yes. So please visit the SCC website for more of a demo of the ad hoc platform.
I'll add a link in the chat for those interested.
Perfect. Thank you, Lisa. Moving on, one other aspect of dispute resolution online is, of course, to what extent people are using virtual hearings, or the possibility of having virtual hearings. This topic has become very much discussed during the course of the pandemic, of course, as we saw restrictions on meeting in person and travel bans as a result of the pandemic. This it has triggered it has triggered a different kind of behavior in our industry. And as I mentioned early on, we now see a very quick, strong shift to moving things online because it's been a necessity to do so. Of course, virtual hearings may have been used to some extent prior to the pandemic, but it's certainly been a very topical question during the pandemic. As far as the SCC is concerned, when the outbreak started in March in Europe, we could see that all hearings scheduled for March were postponed for a later date. But very quickly, we also saw some arbitral tribunals adapting and carrying on. They changed to online hearings, and I believe the first SCC arbitration that moved forward with a virtual hearing was an arbitration, rather large arbitration that had a 2-week scheduled, 2-week-long hearing scheduled in April, and they quickly shifted and set up to make it possible to do it virtually instead. And as I understand, it was very successful. And as the months have progressed, more people have rescheduled their cancelled hearings to an online substitution or virtual hearing, which is very exciting to see from our end, as we are champions of time and cost efficiency, and the technology is out there. It just has not been used to its maximum capacity before the pandemic. And as we see our colleagues getting more and more used to this way of working, we see a very positive response from people who have experienced in virtual hearings. And this led the SCC to wanting to know more about our users' experience of virtual hearings, and therefore we conducted a survey in October, so last month, where we sent a short questionnaire to 150 sole arbitrators or chair person in our cases, and we received 98 responses on that questionnaire. And the various findings were very positive indeed. We could see that hearings in international cases move online to a larger extent than before. In domestic cases, we could see still a mix, increased mix of using in-person and online hearings. But what's striking is to see the high satisfaction rate for both the procedural and the technical aspects of conducting a hearing online. And in this particular questionnaire, most of the arbitrators said they were likely to continue online both during but also post COVID-19. This is a shift and a move forward that is very much welcomed by the SCC. But of course, part of the topic that have been addressed during the last few months is whether or not virtual hearings are legally substitutes to an in-person hearing, and whether or not you can, an arbitral tribunal can force the parties against a party's will to proceed with a virtual hearing. This is, of course, questions that will be decided on by the jurisdiction of the seat of arbitration, but it is indeed a very exciting and promising development, and we will follow it very closely. Right, so what is in store for international dispute resolution? We of course don't know exactly what's going to come out of the current unusual circumstances we find ourselves in now, but I think that it's safe to say that business will continue and international trade will continue. The shift towards a more virtual dispute resolution method will be interesting to follow as we go forward. I think that as far as the SCC is concerned, we offer services, different kinds of services. The dominant one is, of course, services in international and domestic arbitration. But as we see new technologies develop, you have blockchain technology, artificial intelligence, and other forms of technology that may disrupt how business do business and how international trade is conducted. And we are very interested in investigating how this will indeed affect international dispute resolution. Will there be something else other than arbitration that businesses opt for, and what would that solution be? And this is something that the SCC is very keen on investigating and study for further in order to continue to be at the forefront of innovating international dispute resolution. And with that, I am ready for more questions if you have any.
There aren't any questions currently, so if there are anybody who has questions on the different topics we have here, then you are more than welcome to ask them in the chat or by raising your hand.
May I ask if you have any questions, Lisa, or anything that you would like to highlight that I might have missed or that you would like to elaborate on?
Oh, now you're putting me on the spot here.
Oh, sorry.
No, I mean, there was one, I've been answering some questions here on the back end, and one just note is that if anybody is interested in, for instance, using the ad hoc platform for an ad hoc case, they're more than welcome to email, and the address that they should be emailing then is arbitration@chamber.se, and then we can help them set it up. So as I said, that one is free to use, and I can't remember if you highlighted it, but in the demo we said that it's free to use up until with sites initiated up until end of December, and we've prolonged that till end of April, since the pandemic unfortunately doesn't seem to be over just yet. Then this one is prolonged, so you still have some time if you have an ongoing case.
Absolutely. And it is really truly there to be of assistance to parties who struggle in the pandemic, and it was a great initiative taken by our supplier, and it was our joy to really create the ad hoc platform to be used for good in a difficult time. So right. Please reach out if you have any more questions in particular about the ad hoc platform.
And then we got a comment relating to AI when it comes to search for arbitrators and counsels, that should be a field where AI is likely relevant. And I completely agree that AI could serve a purpose there, and when analyzing what AI could do for arbitration, then that's certainly one of the areas that kind of comes as, I wouldn't say low-hanging fruit, because I'm not sure how much AI is low-hanging at all, but I think one of the first things that needs to happen there, to just comment on that comment, is even better databases. And there's a lot of databases where you can gather information beyond mere CVs. And there are databases like that in the works, especially when it comes to a database called Arbitrator Intelligence, which is an American initiative, where they are surveying the participants of an arbitration to ask them to provide information on how arbitrators perform. to add some flavor to their formal competences. So there are definitely a lot of works in the ongoing when it comes to increasing the strength of the tools for finding arbitrators.
Thank you. And if I may add, Lisa is head of business development at the SCC and has been together with me and HiQ creating both the SCC platform and the Ad Hoc platform. So we work very closely together on these topics, and you are welcome to reach out either to Lisa with questions of a more technical nature, perhaps, or to me, both in relation to the SCC platform and the Ad Hoc platform.
And I can take the chance there as well to just plug, if those kind of AI blockchain questions are of interest to you, then there is actually on our website a webinar that I held a couple of months ago that is touching more on those more high level, not necessarily what we do today, but what we might be doing in 10 years. So how will AI and blockchain change the world of arbitration? So that is, if you want to dive deeper into that, you can do that on our webpage.
Very exciting. Thank you, Lisa. Well, if we don't have any more questions, I would like to thank you all for joining me and Lisa here today to learn more about the SCC and the initiatives that we have taken and how we see the digital or dispute resolution online increase and how we see that going forward. We're very happy to answer questions also after this event. So just send us an email either to Lisa or myself. But with that, I thank you very much for your time, and I wish you to stay safe and healthy. Bye.